We're not audible. You could turn off the
Good morning, sir. Are we audible, sir?
Yes, yes, yes.
Thank you so much for doing this, sir. We are really grateful. Okay. Is this starting? Good morning, everyone. It is an honor to welcome you to this important conference on hate speech, an issue that transcends borders, cultures, and communities. In India, 13% of hate content on Facebook targets Dalits with caste slurs and anti-Ambedkar messages, while 37% is Islamophobic. In the US, over half of adults have faced online harassment. Hate speech is not just about words, it has real consequences. Studies show it leads to depression, anxiety, and self doubt, making people feel unequal and lowering their social standing. As Professor Jeremy Waldron explains, dignity means being recognized as a full and equal member of society, included in its ordinary life. But when people are publicly defamed, dehumanized, or made to feel unwelcome through hate speech, their dignity is attacked, and the very fabric of inclusive society is weakened. Today, we gather to examine how hate speech erodes dignity and what we can do to counter its rising threat. It is my pleasure to introduce Honorable Justice Abhay S. Oak, a distinguished jurist deeply committed to constitutional values and social justice. Sir enrolled as an advocate in Bombay in 1983 and built a remarkable legal career over 2 decades before being appointed as a judge of the Honorable Bombay High Court in 2003. Sir later served as the Chief Justice of the Honorable Karnataka High Court before being elevated to the Honorable Supreme Court of India in 2021. Sir has delivered several landmark judgments upholding fundamental rights and social welfare. Just last week, Sir authored a significant ruling quashing an FIR against a member of parliament over a Instagram post featuring the poem "Oh Bloodthirsty Ones, Listen," which had led to allegations of inciting hatred. In this ruling, Sir reaffirmed that free speech is not just a constitutional right, but a foundation for a dignified life. And Sir also emphasized that courts must protect fundamental rights even when the content is controversial or unpopular, and that literature, poetry, and satire play a vital role in enriching society and fostering debate. Beyond free speech, Sir has championed social justice through the law. During Sir's tenure at the Karnataka High Court, Sir directed the state government to prioritize vaccinations for individuals with disabilities under the Rights of Persons with Disabilities Act. Sir also took suo motu cognizance of shocking cases of animal cruelty, emphasizing the need for strong preventive measures. Today, we are privileged to hear Sir's insights on the critical issue of hate speech. And before I just request Sir to address us, I would request Mugdha to introduce our other two distinguished panelists for the day. Thank you, sir.
Thank you so much, sir, for joining us. It is my pleasure to introduce Senior Advocate Colin Gonsalves, with whom I've had the privilege of working for nearly 4 years. As the founder of the Human Rights Law Network, India's leading public interest law group, Dr. Gonsalves has built a national network of over 200 lawyers and paralegals across 28 offices since earning his law degree in 1983. Beginning his career in the labor courts before moving to the Bombay High Court in 1984, he was later designated senior advocate and transitioned to the Supreme Court of India in 2000. Over the years, he's argued landmark cases, including the right to food case, in which the Supreme Court ordered subsidized grain for 700 million poor Indians. His contributions have been recognized with numerous honors, including the International Human Rights Award from the American Bar Association, an honorary doctorate from the University of Middlesex, the Mother Teresa Memorial Award for Social Justice, and the Right to Livelihood Award. Dr. Gonsalves remains at the forefront of critical legal battles, from defending abortion rights and securing the premature release of prisoners incarcerated for prolonged periods to protecting activists targeted for dissent. He successfully halted the mass eviction of poor residents in Haldwani, a district in UP, fought for migrant workers abandoned during COVID lockdown, and challenged the social boycott of Dalits in Haryana. His work extends to gender rights litigation, including the challenge to the Section 375 IPC, which exempts men from prosecution for marital rape, and defending Muslim girls' right to wear the hijab in Karnataka schools. He is also leading the fight against sedition laws and representing students of Jamia Millia Islamia University in Delhi, a central university in India, and members of the Muslim community demanding legal action against hate speech during protests against the Citizenship Amendment Act. Dr. Gonsalves will be speaking on the practical issues involved in litigating against hate speech today, and it is an honor to introduce him today. Our next speaker is Professor Nadine Strossen, a chaired professor emerita at New York Law School and past national president of the American Civil Liberties Union from 1991 to 2008. She is a senior fellow with FIRE, the Foundation for Individual Rights and Expression, and a leading expert and a frequent speaker and media commentator on constitutional law and civil liberties, who has testified before the Congress on multiple occasions. She serves on the advisory boards of the ACLU, Academic Freedom Alliance, Heterodox Academy, and National Coalition Against Censorship. The National Law Journal has named Professor Strossen one of America's 100 most influential lawyers, and several other national publications have named her one of the country's most influential women. In 2023, the National Coalition Against Censorship, an alliance of more than 50 national non-profit organizations, selected Professor Strossen for its Lifetime Achievement Award for free speech. She's the author of Hate, Why We Should Resist It with Free Speech, Not Censorship, and Free Speech, What Everyone Needs to Know. She's also the host and project consultant for Free to Speak, a 3-hour documentary film series on free speech distributed on public television in 2023. Her book, Defending Pornography, Free Speech, Sex, and the Fight for Women's Rights, was named a New York Times Notable Book of 1995 and was republished in 2024 as part of the New York University Press Classics series. Her book, Hate, was selected as a common read by Washington University and Washburn University. It is my privilege to have her here with us.
We would request Honorable Justice Oak to kindly address us, sir.
Good morning, everybody. I compliment Columbia Law School for organizing this debate on hate speech with special reference to hate speech against the religious and caste minorities. Today, of course, I will be discussing this topic with you in the context of Indian context. The speaker who introduced me described me as a jurist. There I beg to disagree with him. I am here as a student of law only because I have been a judge of constitutional courts for 21 years, 21 and more years. I don't become jurist. I was carefully hearing the introduction of the other two speakers. I will not say many things about Colin Gonsalves because he continues to appear before me, but he is an activist. That much I can surely say. The other speaker is also a very distinguished speaker. All of them have written books, articles. What I have done is only writing judgments and nothing more than writing judgments. And whether they are really good or bad, it is for somebody else to decide. I can't say that. So basically, today I am here as a student of law. I always say this that even as a judge, I may not be necessarily right. Today also, I may not be right. You may disagree with me on my views. I must tell you some background because I see some of you are Indian students. I see some students from other nations. For them, I must give you some background. Our country, India, is a unique and distinct one. This country does not have common language like USA or many other countries which have common language. Perhaps every state in India has a different language. There are different religions. Hindu is a religion of majority. Now, Hindu religion is also very peculiar. Hindu religion is characterized by its complex system of caste. Apart from religions, there are ethnic groups. More importantly, there are classes of Indian society who have been oppressed for centuries. They are scheduled castes, scheduled tribes, nomadic tribes, and other backward classes. This is where India differs from most of the larger nations in the world. Even with this level of diversity, India remains a democratic country right from 1947, and in particular from 26th of January 1950 when we gave ourselves the constitution. Most of you must have studied Indian constitution. It confers various freedoms on Indian citizens. Today is not a day to discuss that, but someday you must go into the history. Why these freedoms were required? One reason was India was a British colony for centuries. And freedom struggle started from 1857, which ultimately ended in 1947. And in freedom struggle, we are seeing how the British government targeted the freedom fighters, charged them with sedition. Many were prosecuted for even shouting slogans. Many were detained because they participated in satyagraha. And therefore, it was very necessary for the framers of the constitution to provide these freedoms, because without these freedoms, independence has no meaning. It is very ineffective. And as you know, one of the most important fundamental rights which is conferred on the citizens under Article 19(1)(a), that is the right of freedom of speech and expression. It is most important fundamental right which is conferred by the Constitution. In Indian Constitution, there are two categories of fundamental rights. The fundamental right under Article 19 is available to the citizens. But the most important fundamental right is Article 21, right to life, which is all pervasive. It is available to everyone, whether he is citizen or non-citizen. That's very important for young students to understand. Because whenever we discuss hate speech, apart from 19(1)(a), freedom of speech and expression, necessarily Article 21 comes into picture because the Supreme Court, by various judgments, has expanded the scope of Article 21. As the speaker who introduced me talked about right to live with dignity. This is something which is basic right, which should be available to any human being. That right to live with dignity is integral part of Article 21. And please remember that even if foreign citizen is on Indian territory, he has that right under Article 21. And therefore, I always say when I address the young law students that our jurisprudence on the criminal side is very unique. A terrorist who participated in 2008 bomb blast was a foreign national. We gave him full trial when his appeal was before the High Court. A very senior advocate was appointed to defend him. So, therefore, Article 21 is very important. Now, without freedom of speech and expression, no one can say that he can live with dignity. It is again, Article 19(1)(a) is linked with Article 21 because where is the right to live with dignity unless there is a freedom of speech and expression? Now, when we talk about hate speech, we have to necessarily consider Clause 2 of Article 19, which indicates that freedom of speech and expression under Article 19(1)(a) is not absolute. Clause 2 provides that by legislation, reasonable restrictions can be imposed on exercise of right under Article 19(1)(a). It's not a blanket power conferred on the legislation. If you read Clause 2, it says that reasonable restrictions can be imposed in the interest of sovereignty and integrity of India, for security of state, for public order, for decency, morality. Only if a reasonable restriction is imposed by a law framed by legislature, then there can be curbs or restrictions on Article 19(1)(a). If legislature comes out with a law which imposes unreasonable restriction on the fundamental right under Article 19(1)(a), that law can be struck down either by the High Court or by Supreme Court. If we consider various legislations by the state and central government, you will find the legislations which are covered by Clause 2, which impose restriction on exercise of fundamental right of freedom of speech and expression. You will find that in none of these legislations, hate speech has been defined. Though hate speech has not been defined, it is an area of concern for right-thinking people across the world. We completed 77 years of independence on 15th of August 2024. 77 years of existence of independence, 75 years of existence of our constitution. It is very unfortunate that in India we come across several cases of hate speeches. That is one side of it. We also come across in our country gross violations of Article 19(1)(a), freedom of speech and expression, as well as right to life under Article 21. Though the legislature has not chosen to define hate speech, and there are good reasons for that, broadly we can say that it is a speech. It may be oral, it may be by words, it may be any form of communication, it may be by signs also, visible signs also. So hate speech is one which spreads hatred against a race, religion, caste, or group of individuals. It is a speech which targets particular groups, religions, races, castes. Hate speech, broadly speaking, can amount to a speech can, broadly speaking, a speech can amount to hate speech, provided the effect of the speech is to provoke people to indulge in violence, or effect is that to instigate one group to fight against the another. The earlier speaker rightly said that if any society, in any democracy, if hate speeches are allowed, it certainly affects right to live with dignity. Right to live with dignity becomes meaningless because when hate speech, when there is hate speech against a particular community, say for example in India against a religious minority or a scheduled caste or scheduled tribe, it takes away right of the person against whom that speech is addressed to live with dignity. So hate speech may be offending various laws which are covered by clause 2 of article 19. At the same time, hate speech also takes away fundamental right under article 21. There are judgments and judgments of the Supreme Court on different aspects of hate speech. There are judgments which deal with concept of hate speech. One of the judgment of the Supreme Court has in fact enlisted provisions of various statutes which deal with hate speech. These are all penal statutes. The judgment enlists those hate speeches. There are judgments of Supreme Court which lay down guidelines for guiding the executive to ensure that there is no hate speech and those who indulge in hate speech are brought to the book, they are punished. Broadly speaking, maximum provisions about a hate speech, you will find it in traditional penal legislation, which was Indian Penal Code of 1860, which was in force for so many years till 1st of July 23, when we have this new legislation, new penal law, a new general penal law, I term it like that, known as Bharatiya Nyaya Sanhita 2023. Of course, provisions are more or less same. Before I deal with the provisions of this this penal legislation, there's one more aspect in Indian context. Unfortunately, in our country, practice of untouchability prevailed for centuries, and persons belonging to certain caste were treated as untouchables. And therefore, you find Article 17 in the Constitution, which declares untouchability is abolished and it shall be an offense punishable in accordance with law. There are laws in force which are enacted to give effect to the fundamental right under Article 17. First is the Protection of Civil Rights Act 1955. Under this legislation, anyone who incites or encourages any person or class of person or the public generally to practice untouchability by spoken words is guilty of an offense. If any person belonging to scheduled caste or scheduled tribes is insulted by spoken words on the ground that he is untouchable, it is an offense. So ultimately, when somebody speaks and calls a community or an individual or a class of individuals as untouchable, it is also a hate speech. Then there is Article 15 of the Constitution of India, which is basically targeted to meet the challenges in India. The challenges were faced by backward communities like the scheduled caste, scheduled tribes, nomadic tribes, other backward classes. Untouchability was not the only thing. They suffered from discrimination. To put it broadly, they were not treated on par with other citizens. And therefore, there was need for Article 15, which is prohibition on discrimination based on religion, race, caste, sex, etc., your place of birth. There was one more facet when the framers of the Constitution found that these backward communities, apart from facing social stigma, untouchability, they are denied opportunity in employment. And therefore, we have Article 16, which confers a fundamental right on every citizen to equal opportunity in the matters relating to employment, appointment in office, etc. Notwithstanding all these provisions in the Constitution, notwithstanding that 1955 Act I talked about, the atrocities on scheduled caste and scheduled tribes continued. And therefore, In 1989, we had one more enactment dealing with this issue, that is the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. So it is significant that we had constitution in 1950 and 1989. After 39 years, a requirement was felt to have legislation to prevent atrocities on Scheduled Caste and Scheduled Tribes. Even this law makes certain speeches as hate speeches and penal consequences follow. For example, under this law, if any attempt is made by anyone through spoken words or through written words to promote feeling of enmity, hatred, or ill will against the members of the Scheduled Caste or Scheduled Tribes, it is an offence for which minimum punishment is 6 years, 6 years of imprisonment. That's the minimum punishment. If by spoken words any disrespect is shown to any late person held in high esteem by the members of the Scheduled Caste or Scheduled Tribes, it is again an offence punishable with minimum sentence of 6 months. Now, this has a context. The framer of the Constitution, Dr. Babasaheb Ambedkar, had to face these hardships. He also belonged to a backward community. And this provision, which says that if by spoken words any disrespect is shown to any late person held in high esteem by members of the Scheduled Tribes and Scheduled Castes, it is an offence. And earlier speaker said that even today there are instances of hate speeches against Dr. Babasaheb Ambedkar, who has given us this constitution. We, the students of law in India, we proudly say that this is the best constitution in the world. Again, as I said, we may not be right there, but we feel that way, that it's the best constitution which is given to us by Dr. Babasaheb Ambedkar and his colleagues. And in this particular statute, 1989 Act, which protects atrocities, prevents atrocities on Scheduled Castes and Scheduled Tribes, there are stringent rules for bail. In India, most of you must be aware that there is a concept of pre-arrest bail. If any person apprehends that in connection with any cognizable offence he is likely to be arrested, he can go to Sessions Court or High Court and apply for pre-arrest bail. So he is protected in advance from arrest. So under this statute, there is a prohibition on grant of pre-arrest bail. Now, one of the main objects of this act, apart from preventing atrocities on Scheduled Castes and Scheduled Tribes, is to prevent hate speech. Nobody can hate the backward classes in India. Now, coming to the traditional laws, namely Indian Penal Code or now it is replaced by Bharatiya Nyaya Sanhita that came into force on 1st of July 2024. Now, one of the basic offences there, all of you must have heard about it, is Section 124A in Indian Penal Code. Now, Section 124A is an offence of sedition. During British regime, this offence was very often applied to eminent freedom fighters. But there are cases of misuse of this provision even in independent India. Now, ultimately, what is sedition? That is under Section 124A of IPC. When somebody by spoken or written words attempt to bring hatred or attempts to excite disaffection towards the government elected by law, it becomes offence of sedition. Now, this disaffection has been given inclusive meaning. It is all forms of disloyalty or all forms of feeling of enmity. So this is one very important provision dealing with the hate speech. This is a hate speech, to put it broadly, against the government elected by law. How and when this provision has been misused, it's a separate subject we discussed. Then comes Section 153A in the Indian Penal Code, which is equivalent to Section 196 of the new Penal Code, which was enacted in 2024. It is about spoken words or written words or by gestures. The provision is that if by spoken words or written words, enmity between different groups on the ground of religion, race, place of birth, residence, knowledge, etc., is promoted, and if any acts are prejudicial to the maintenance of harmony between different groups, it becomes an offense. Even spoken words intended to outrage religious feelings or religious, if there is insult by spoken words to religious beliefs, it becomes an offense under section 295A of the Indian Penal Code. Even if somebody speaks in such a manner with the intent to cause any member of the armed forces to mutiny, it is an offense. These are all penal provisions. We seek to penalize anyone who indulges in different categories of hate speeches. There are different categories of hate speeches. One, as I said, is sedition. The other speeches are in relation to scheduled castes and scheduled tribes, oppressed classes in India. It is against religious minority. There are instances in India where there are hate speeches against the religious minorities, and attempt is made to provoke the members of the majority to attack the religious minority. So these are all provisions which take care of different categories of hate speeches, and please remember that all these hate speeches which fall in this category, they are made offenses which are punishable with imprisonment and fine. There are other hate speeches, like for example, we have Representation of People Act. Those who contest the elections for Lok Sabha, the House of Legislature in state and in at center, if they indulge in hate speeches, there are offenses. As I said, 75 years of existence of Constitution. We celebrated that event on 26th of January this year. But after 75 years also, there are many instances of hate speeches. Most of the hate speeches in India, I may be wrong there, but because I have only perspective of cases which come before the courts. At grassroots level, what really happens, perhaps the activists like Dr. Gonsalves and others will be able to tell you more effectively. But in the court, we come across cases where mostly these hate speeches are against the religious minorities or castes which are in minority. They are oppressed classes like scheduled castes. Basically, these keep aside the penal part of it, whether a speech becomes offense. But basically, these speeches disturb the social harmony. And perhaps the activists will be able to tell you in better fashion, or those who are studying the pattern of hate speech in India very systematically, they will be able to tell you there can be political reasons also for hate speeches. Maybe some political leaders, for gaining advantage in terms of electoral politics or gaining advantage to get votes, may be indulging in hate speeches. But that's a matter of study, and it requires study, because we always believe that we should have very healthy democracy. And if in healthy democracy, political elements are going to use hate speeches, it's a matter of great concern. So there are numerous statutes which provide for punishing individuals for those who indulge in different categories of hate speeches. As I said, Supreme Court of India has issued several directions for prevention of hate speeches, for ensuring that once there are cases of hate speeches, the offences are registered, criminal law is set in motion, and criminal law is taken to its logical conclusion. But these are preventive measures which are supposed to be undertaken by the executive. But real challenge is to educate masses against the hate speeches. That's the main challenge. Because unless we are able to educate masses against the hate speeches, these efforts made by the courts by issuing directions will have its own limitations. And most important thing, in our preamble, you must have read our preamble of the Constitution. The citizens of India have assured themselves various freedoms And apart from freedom, fraternity. Fraternity is very important ingredient of our preamble to the Constitution. If we are able to maintain fraternity, if we are able to educate masses about importance of fraternity, automatically the instances of hate speeches will go down. This education is very important. By educating masses, we can strengthen their minds, because ultimately hate speeches have some effect on some people because they have weak minds or they are polarized in terms of thinking. So therefore, this public education is very important. And public education should be giving emphasis on achieving social and communal harmony and fraternity. When I say this, you have to remember one more very legal aspect of these provisions. Somebody may say that so and so has delivered hate speech. But please remember that only because one or two individuals or three or four or a group of individuals feels that it is a hate speech, it does not become hate speech. There are judgments laying down in what cases it will be a hate speech. It's not individual perception. Because if we go by individual perception that a particular utterance is a hate speech, and we start branding it as hate speech, we will be compromising on fundamental right of freedom of speech and expression. In fact, I some time back I discussed the offence under section 153A of Indian Penal Code. That is whereby spoken words, somebody encourages enmity between different groups of on the ground of religion, etc. Somebody tries to promote that enmity. The Supreme Court and High Courts have laid down tests, because when the courts deal with these hate speeches, these are the penal provisions, courts also have to keep it in mind that the laws must be interpreted in such fashion and such manner that freedom of speech and expression is not taken away. I talked about dignity of life which is guaranteed under Article 21. If there is no freedom of speech and expression, there is no promotion for arts, literature, and the judgment which the speaker referred, we also referred to various other aspects of art, satire, stand-up comedy. If this is divorced in the sense that we start attacking this part of freedom of speech and expression, there won't be any dignity which will survive in life. Right to live, dignity will disappear. Therefore, when courts have interpreted these provisions regarding hate speeches, the courts have tried to strike a balance. The courts have always ensured that freedom of speech and expression is protected. In fact, for offence under section 153A, there is a test laid down. Now the test is ultimately when all these offences the court considers, the court has to consider what is the effect of those spoken words or written words or those expressions or visible signs. The courts have laid down tests. That test is laid down by one of our greatest judges, Justice Vivian Bose, who became judge of the Supreme Court. While he was judge of the Nagpur High Court, he has laid down the test, which is now uniformly applied during the last 50 years. Now the test is, what will be the effect of spoken words on by considering standards of reasonable, strong-minded, firm and courageous individuals. And the standard is not based on standard of people who are weak or those who are having oscillating minds. We can't go by the standard of those people who have sense of insecurity, or they always feel that somebody criticizes them, it's a threat to their power. So therefore, those standards have been laid down. Every speech, ultimately court has to consider what will be the effect of the speech on the mind of human beings, on the mind of citizens. And therefore, this test has been adopted. If we say that a particular speech is a hate speech because it affects somebody who has very weak and oscillating mind, then perhaps the scope of hate speech will be very widened, and then we'll be depriving ourselves of the freedom of speech and expression. So this striking the balance is very, very important. In democratic setup, dissent is also very crucial. When we talk about right to express your own views, dissent is also very important, and that is in fact ingredient, or that is necessity of any healthy democracy, to have a dissent. There's a right to protest also. If something is happening in society which according to individual is not correct, he has right to protest also. Of course, when it comes to right to protest, I request young students to read the last speech by Dr. Babasaheb Ambedkar in Constituent Assembly on 25th of November 1949, where he said that yes, even in independent India, after the constitution comes into force, the right of protest will be there, right of dissent will be there, but the protest has to be by constitutional means. The protest has to be within the four corners of law, because that is the essence of the democracy, that when you protest in accordance with law. But at the same time, what is important is right to protest. And therefore, when we talk about hate speeches, ultimately the courts have to balance it with other rights available. Right to dissent is also required, right to protest is also required. It is part of our dignified life. Because if as human being, I feel that a government policy is completely wrong, it is against the interests of common man, I should have the right to protest. Otherwise, my life becomes, my life is not meaningful at all. But it is necessary to remember that the protest and dissent has to be by constitutional methods. Therefore, talking about the students, I am now coming back to the students. In Indian context, there are universities in India where students are allowed to form associations or unions. In some universities, the students are allowed to form committees. The idea is that students are able to express if they have some grievances about the manner in which the university or education establishment is conducting itself. Such institutions give voice to the students to express. And therefore, as I said, there has to be education right from the school or college days to ensure that we built up a very healthy society. We built up a society which gives importance to social harmony and fraternity. And therefore, it is very important for our universities also to allow the students to express themselves, allow the students to protest if they are suffering from injustice within four corners of law. The provisions regarding hate speeches or provisions which make certain speeches or utterances or spoken or written words as offenses, those provisions cannot be abused or misused to prevent people from expressing their views, expressing their dissent. Therefore, it's a huge challenge before any legal system, and especially in democratic countries. One, our constitution in India, talking Indian context, our constitution preaches social harmony, equality. It preaches fraternity. And therefore, on one hand, the lawmaking institutions or the courts have to come down very heavily against speeches which are really hate speeches, which are made offenses. But at the same time, balance has to be struck to ensure that the freedom of speech and expression remains unaffected. Right to dissent, right to protest remains unaffected. And that's a huge challenge before our society, that's a huge challenge before our legal system. And therefore, this is one area, hate speech, the freedom of speech and expression. This is an area where there is always a scope to evolve the law, evolve the new legal principles, evolve new concepts. Expression, we have to also take care of the changing society, the changing needs of the society. And therefore, I began by complimenting Columbia Law School for choosing this subject. And my idea of having a dialogue with you is not to teach you, because as I said, I am also a student of law. I am just expressing few things which I know as a judge is based on my experience. The idea is to ensure that the young legal minds and brilliant legal minds which are there in Columbia Law School, they start thinking about it. They start evolving, they start developing new concepts, and they start making research on this aspect. So again, I thank the organizers for giving me this great opportunity to interact with young students. And I hope that you'll be really enriched by the other two speakers because they have more experience in the field. I again thank the organizers.
Thank you so much for this insightful speech, sir. We are really grateful for your time and for your wisdom. And I'm sure all of us learned a lot in these 30 minutes as compared to sometimes how much we even learn in a semester. So thank you so much for this insightful speech. Before we open the floor to some questions from the students and the participants on Zoom, a couple of questions have been relayed to us. A couple of questions have been sent to us to be relayed to you. So we would just want to ask a couple of questions.
Yes,
So,
please.
sir, one thing is that. So you spoke about maintaining a balance between maintaining the right to free speech and when it may transcend to hate speech. So what should be the broader goal or the standard of review when we're talking about assessing whether a particular speech is hate speech or whether it falls within the contour of free speech? So say, for example, should it be violation of dignity of a minority as a class, or should it be incitement to hatred as the standard is right now under Section 153A IPC? Why this question has been put is sometimes what happens is that when a speaker is indulging in hate speech, they may not really be thinking of violence as a consequence. They do not want to incite violence, but their sole intent is to dehumanize a particular class or race or community by ensuring that they get the message that they are an inferior race or a community. So when their whole consequence or their whole intention is not to spread violence, sometimes the standard of intention to incite violence may or may not be the right standard. So we just wanted to know your views on this as to whether violation of dignity, which is a much broader standard and maybe a vaguer standard, should that be the standard of review, or something which is like an imminent threat to violence, which is a more objective standard, should that be the standard on which we assess hate speech?
See, frankly speaking, I find some answers in your long question. When you ask the question, there are answers which are given by you. See, basically, I am again speaking in the Indian context. When does a speech become a hate speech? As I said, there is no written concept of hate speech. There is no definition of hate speech. Basically, spoken or written words or visible expressions, signs, or whatever method of communication, it becomes hate speech when it becomes a penal offense. Otherwise, it's not a hate speech at all. So this first concept you must remember. Now, broadly, I discuss various provisions with you, which are the offenses relating to hate speech. If you carefully study these provisions, the concept differs from offense to offense. The standards differ. It ultimately depends on, see, there are so many factors. As I said, as far as offense under Section 153A is concerned, the test is what is the effect on a person with reasonable mind. That's the basic test in some of the offenses. But it depends. If you want to decide whether a particular hate speech is an offense, the first thing is place at which the hate speech is delivered. The circulation of that hate speech, whether it is spoken in front of only 15 people, or it is widely circulated, it is telecast on YouTube, or it telecast on television, then who forms part of the audience. Because ultimately, if you see all the offense, barring few offenses, which conceptually make hate speech as an offense, but otherwise, what is important, broadly speaking, again, what is the effect on the persons who have heard or read the hate speech? That is also a test laid down. And as I said, test laid down is effect on not every human being. Ultimately, effect on human being which is having reasonable mind. Again, the test in case of offenses against scheduled castes and scheduled tribes are different. Perhaps it is more axiomatic, because if you utter certain words, then perhaps it will amount to hate speech. In every case, consequence may not be any consequence, or whether what effect it has on the person who hears is, that is inconsequential. Some of the offenses under the Civil Rights Act and SC/ST Act are those offenses. So therefore, you have to remember that you cannot apply uniform standards. You have to go by the provisions of the penal statute. And that's very important. You can't generalize concept of hate speech. Otherwise, if you generalize it, it has serious consequences. If you generalize it, then I, as an individual, I will feel that this is hate speech, and therefore, person should be prosecuted. That is not the standard. Therefore, I repeat what I said. Only because few individuals feel that a speech is objectionable, it does not become objectionable. And therefore, while applying the standards, while applying the tests differ from offense to offense. And these are evolving tests again.
Professor Nadine just wanted to address something.
Thank you so much, Justice Oka, for that very enlightening presentation. I love the fact that you describe yourself as being a student as well as as somebody who's teaching all of us. It's a mutual process, and I'm grateful to you and the distinguished co-panelist, Mr. Gonsalves, for sharing your wisdom and helping us all learn together. I'm grateful to the wonderful students who have organized this. I was very struck by the fact that you began your remarks by highlighting India's constitutional protection for the rights of non-citizens. And in the United States, virtually the entire Constitution, including the most important rights, the most fundamental rights, are clearly guaranteed not only to non-citizens, but to every non-citizen, even somebody who is here without legal authorization. In my country, as you know, we sometimes have government officials who don't adhere to constitutional standards. I'm sure that doesn't happen in India, but we are so dependent on organizations like Mr. Gonsalves's, equivalent to the ACLU and other organizations in the United States, and to judges who enforce constitutional principles against intransigent government officials. And that's a process that is going on in the United States right now. The judiciary and the legal profession, civil society, human rights groups have never been more important as rights of non-citizens and students and lawyers and others are under siege. So many, many thanks for your essential contributions. To the justice, I had not been aware of the more recent decision that Devanshu mentioned today, but I had read an earlier decision of yours that seemed very similar, and I was so strongly impressed, and you said it in your oral remarks a number of times also, but I want to underscore it, that dignity is a value that weighs on both sides of this debate, right? As we are striking that delicate balance, as we all try to do, of course, we're concerned about the dignity of those who have traditionally been marginalized and don't want it to be undermined by hateful speech. But on the other hand, dignity also includes the right to express yourself, including in ways that a government might deem to be hateful and to fall afoul of hate speech laws as an opportunity to suppress dissent and protest. And, in your remarks here, as well as in your opinions, you have been so eloquent in describing how protest and dissent are an essential aspect of human dignity. And in our wonderful, understandable zeal to protect against hate speech, we have to be very careful that we do not intrude into the right to protest and dissent. And I also love that you stood up, so to speak, for stand-up comedy and how important that is to human dignity. So that wasn't a question. It was just a comment and a thank you.
But a very interesting comment. I'll put it that way.
Thank you so much again for joining us, Justice Oka. I just have one question before we can open it up to the audience. And this may be a very overbroad question, but I was wondering if, since you were talking about striking a balance and determining a test in terms of where do we point towards, where do we protect dissent and where do we punish hate speech? I was wondering, like, do people who wield more social capital, should they be put to a stricter standard because of what impact their speech can have on the audience? Like you were talking about how it's disseminated, who's the audience, and where does that, how do we address that, and how should possibly courts address that?
See, there is one thought process. I have not applied my mind to that. I read certain articles, I have heard people talking in seminars. One is that you apply stricter standards to speeches of politicians to decide whether it's a hate speech or not. Because ultimately they are to public.
Justice Oka, you're not audible. I believe there may be a network issue.
Colin, sir, can you hear us? Okay. Okay, so then maybe it's yeah.
Speeches or public utterances. Yes, I think there are some.
So I think there is some network issue. Are you able to hear us?
Can you hear me?
Now we can hear you, sir.
Now, can you
But
hear
it's
me?
Yes, yes, sir. Now we can hear you.
Yes, you can hear me. Right. So therefore, that's a very debatable issue, whether you will apply.
So it's
I think there's some disruption. Now, can you hear me?
Yes, sir. We can hear you, sir.
so there still seems to be a little bit of a trouble.
Maybe, sir, if it's a bandwidth issue, maybe you can switch off your video and we would be able to hear you.
Can you hear me now?
No, sir. It's breaking again and again.
Now, is the quality improved now?
It's better, sir.
Better, sir.
Oh, better now. Yes. So,
Sir, unfortunately, it's still breaking.
answer, it's a very debatable area about the standards to be applied. What I personally feel on the basis of mind that
Sir, are we audible?
can you hear me now?
Yes, we
yes,
can
sir.
hear you.
Right, right. So, therefore, to conclude, I personally feel that we have to go on case to case basis, find out what is the allegation, what is the evidence adduced. That's the only way of dealing with such cases.
Thank you so much, sir. Now we'll open the floor to the audience and if anyone has any questions.
Thanks for this wonderful speech. This is the age of artificial intelligence and deep fake and stuff like that. So I would like to know your view that what is the role liability of service provider, because many time what happens, service providers are being regulated by government and not in good ways but in some negative ways, that they target oppositions and they target some prominent dissenters of the society. So how do you see in terms of, I mean, because we have studied in India and judiciary is the guardian of fundamental rights. So being a guardian of fundamental rights, how do you see your role to, I mean, adjudicate or defend the rights of most marginalized in the society? Thanks a lot.
Again, we come back to square one. What you are trying to say is that certain category of media or certain mediums are being targeted. Again, the same question arises there, whether it is electronic media, whether it is Instagram, it is any other social platform. Ultimately, test is the same thing. Test is whether it is really a hate speech. It is really a speech uh, which becomes an offense under the Indian laws. The tendency will be always there. Suppose I'll give an example. Tendency will be always there. Suppose we take a television network. If the rulers find that that television network is very often critical of the system, very often critical of the ruling party, there will be always a tendency. But then there the right-thinking people in the society, and of course judiciary will have to step in. And I wanted to say that, I forgot to say that. Now, role of NGOs is very important. And someday I'll appeal to you to study the network created in India of legal services authorities. In fact, while dealing with hate speeches, because ultimately object of legal service authorities to ensure that those who are not in position to knock the doors of the court, those who are not able to seek the justice, maybe due to social, economic, and other compulsions, the duty of these legal service authorities, which are statutory authorities attached to the court, is to ensure that people get access to justice. Now, these are the authorities which have to work very hard in the area of hate speeches also, both ways. That these authorities must ensure that all genuine cases of hate speeches are taken to the court, offences are registered, and at the same time, somebody is being targeted, then these authorities must step in and protect the freedom of individual.
Thank you, sir. Do we have any other questions? Are there any questions on Zoom?
Yeah. Can you kindly unmute yourself and ask the questions, whoever has raised their hand? Okay.
Am I audible?
Yes.
Yes.
Yes, you're audible.
Good afternoon, sir. My name is Sushant Singh, and I'm a Dalit and Ambedkarite myself. And I graduated from NLU Delhi and the SOAS University of London, the masters. And I have been growing myself with the legal education, where I've been taught that there are four pillars of the democracy, and two of them has been judiciary and the legislative bodies, which is the parliament. So, there have been attempts in the past where SC/ST Atrocity Act have been diluted to an extent, and I would like to mention two incidents. One of them is recently in the November 2024, Rajasthan High Court gave a judgment where they said the calling somebody bhangi, neech, and so on and so forth, which is being derogatory and an offense under the SC/ST Act, is not an offense anymore. So, if such kind of decisions is given by the high courts in India, then the rural areas are going to have more kind of interaction or sort of comments on a regular basis. And second pillar is the parliament, where we witnessed last year, a year before that, where the MP Danish Ali received few objectionable remarks by the another MP in Delhi. So what I'm trying to ask you, sir, is that if such kind of things are being allowed and SC/ST Act has been diluting with time, and you yourself mentioned during the lecture, it was a very insightful lecture, sir. You yourself mentioned that such kind of remarks are an offense in itself. If such kind of things are coming from the institutions like judiciary or the parliament, then how should we deal with it? Thank you, sir.
Firstly, you talked about decision of Rajasthan High Court. I will not directly deal with that decision. The reason is that though I have short tenure left, maybe that case will come before me. But two things you must remember. One is, of course, I have said it openly, and that's a settled principle that we judges are also prone to committing mistakes, and therefore, if right-thinking people of the society feel that a particular judgment of the Constitutional Court, High Court is also Constitutional Court, it has gone wrong, then it is necessary to ensure that redress should be sought from the higher court, namely the Supreme Court. And I want to tell you something more about it. Now we have state judicial academies, we have national judicial academy. I'm talking more about state judicial academies. We actually educate and impart training to the judicial officers who work as magistrates or district judges. Now, during last about 7 to 8 years, because I have been a regular visitor to all the judicial academies, now we are giving more emphasis on these statutes, social statutes like SC/ST Act and many other statutes. Now there is some kind of emphasis because, ultimately judges who occupy the chairs are also human beings. So they may be committing mistakes. But right-thinking persons of the society, the members of the bar, social organizations must take such decisions to a higher court. If a particular decision is completely wrong, it should not happen. And it should not happen after 75 years of constitution. But the real solution to that is imparting proper training to the judicial officers and the judges. And second question was, you asked me about what happened on the floor of the parliament. As I'm today occupying office of the judge of the Supreme Court, I have certain constraints. Maybe after I demit office, I'll be able to answer that question more freely, but today I'll choose not to answer that question, that part of the question.
Thank you so much, sir, for your response. Um, I would like to invite the other panelists if they have any questions from sir.
Yes, yes. It's a unique opportunity for Mr. Gonsalves to ask questions because normally he asking questions in the court and he has to answer.
Uh,
No, sir, it's just an honor to be with you. Really, such an honor. And to those of you in the audience who do not know, Justice Oak has a huge fan following among young lawyers. Huge.
Can I ask?
Yes, please.
Thank you so much.
Now we can take one question now. Yes.
Thank you so much, Justice Oak, for being here. I actually had a question regarding what you said in the earlier part of your presentation about sedition laws and how that has to also be factored into the nexus of freedom of speech, hate speech, etc. And I was wondering how you would place that and the restrictions placed on individuals and how they may sometimes, in fact, be used to curb dissent and be, used to curb freedom of speech, and what your opinion is on what the standard should be when it comes to sedition, what the standard should be for curbing speech when it is criticism of the government. Thank you so much.
See, here I'm just expressing my views as student of law. I personally feel that the penal provisions dealing with, broadly speaking, hate speech, we call it that way, which deal with hate speeches against the oppressed class, minority, religious minorities, the oppressed classes like scheduled castes and scheduled tribes. Perhaps the approach will be different because these are the classes which are protected by fundamental right themselves, some other fundamental rights under the Constitution. When it comes to offense of sedition, I think different standards will have to be applied. Because again, when it comes to offense of sedition, of course, somebody says that I want to wage war with the nation itself. That's a different thing. But otherwise, in many cases, I'm going back to the pre-independence era. Now, eminent freedom fighters were charged with sedition. So sedition has something more to do with the dissent and protest. Don't take it as official pronouncement of law. This is my personal view. I am not, rightly or wrongly, I have not never dealt with the case of sedition as a judge and as a lawyer also. But perhaps the approach should be different because the scope of offense is different. So that way, sedition is a standalone offense. And of course, Mr. Gonsalves, you asked a question to him, he'll tell you that there is a demand now that the democracy has survived in India for decades. So why there should be this offense at all? That's a demand, ongoing demand. Right, whether it's right or wrong, we require a lot of debate.
Thank you so much, sir. I would now invite Mr. Colin Gonsalves to address us.
Can you give me leave of absence? Because as some of you must be knowing, I'm demitting office on 24th of May. So many things are to be done within short time. So I would have loved to hear Mr. Gonsalves and other speakers, but I'll seek leave of absence from them.
Thank you so much, sir, for your time, sir.
Thank you, sir.
It was a great pleasure to be with all of you. Thank you.
Thank you so much, sir. Thank you.
And so congratulations on your tenure. Thank you so much, sir. Thank you. Colin sir, you may start.
Good morning, everybody. And like I said, it was an honor to be here with Justice today.
So you're audible.
Yeah, okay.
Yes, sir.
Yeah. So I want to start with going back a little bit to sedition, which is the topic where we stopped the discussion just now. And sedition law has much to bear on the present situation on free speech and hate speech. The Privy Council had a lot of differences among themselves. One strain of the Privy Council judgment said that speech by itself is a crime if it's spoken against the government. And the fateful words are, whosoever by words, ... So sedition penalized free speech, and very severe punishments followed for criticizing the king or the queen, as the case may be. There was a second line which said that if we penalize speech per se, then freedom of speech and expression means little. And so the second line said, free speech or hateful speech, let's say, against the government, must be accompanied by an overt act of warfare against the government. After independence in Kedarnath's case in 1968, a constitution bench of the Supreme Court followed the second line and said that free speech is free speech. It can be restricted only on the grounds stated in the Constitution, which means that if your speech is obnoxious or hateful to some, excessive, you can't curtail free speech at all. But to curtail speech, if that speech is accompanied by warfare, then that is sedition and punishable by law. Many countries remove sedition, repeal sedition. In UK, where we took our cue from, that repealed sedition decades ago. But India is a very repressive society, my dear friends. Remember that. We talk of our constitution, we talk of our glorious values, we talk of Indian morality, we talk of all kinds of things. But India is a very repressive society. The bottom line is they don't like free speech. Hang the constitution, hang whatever said. Nobody likes free speech, and they will persecute you for free speech, notwithstanding. And here again, never mistake wonderful judgments with the truth in India. Wonderful judgments. But the reality will be exactly the opposite, and you live in that kind of a eclectic admixture of both. So never go by judgments. In trying to understand Indian constitutional law, go by judgments and go by practice. Like Justice Oak said, activism, practical reality, struggle for justice, movements for social change, put all that together in an admixture to understand constitutional law in India. Now, a very enterprising judge of the Supreme Court, one day while sitting in court, took it upon himself and his colleague judges to say, stay on all sedition cases. So it was stayed. Because there were cases all across the country. There must have been 400, 500, 600 sedition cases. Penalizing a person for scolding the prime minister, saying some hateful thing against the government, saying some obnoxious thing against some politician who deserved to be spoken in. And I had a client from the Northeast who was so fed up with the chief minister of the state in a press conference that he used an expletive. He used a swear word against the chief minister. Dear friend of mine, hot-headed journalist, used a swear word. And he was caught by the scruff of the neck and taken to jail for 1 year for swearing against the chief minister in a sedition case. So anything that you're told about India, please don't believe any story that India is really a democratic country. Less and less and less and less. And now with the present government in charge, I think, oh, that democracy is almost evaporating and disappearing and dissolving and going away. So that's as far as sedition is concerned. Then you have a new law coming in. So I quickly looked through the new law to see what it said about sedition. And I saw those horrifying 3 ominous words, whosoever by words. And I knew that has come back again. And sedition is going to last. As long as India lasts, sedition will always be the law of the land. Now, free speech is also, and the free speech judgments of the 50s, 60s, 70s, 80s were wonderful judgments. India had come through this colonial struggle against Britain, against the British. We were totally enthused with struggle and change and the power of ordinary people to take a colonial tyrant and throw him out. So our minds were like that, rebellious, free thinking, wonderfully energetic, entrepreneurial minds. And you look at the judgments on free speech. Take, for example, Rangarajan's case, which is one of the leading judgments. Speech hateful to the government is protected by the Constitution. Hateful to the government. And there's another formulation which says, let a few noxious branches grow. So it's noxious, it's obnoxious, it's unbearable to hear. I can't accept this. But it's part of free speech. Free speech is not just meant for very polite speech. It's meant for something that makes you upset, perhaps. Makes you not like what is, makes you want to catch the speaker by the scruff of his neck and shake him up. That's the vibrancy of free speech. And so you have Rangarajan's case and so on, living uneasily with sedition law. And sedition law put so many of my friends and colleagues in jail. A cartoonist put in jail. People just protesting and speaking against government put in jail. And like I said, even a swear word will get put in jail. Has that situation changed? Not at all. Is it the situation today? Yes. Can you dare speak against anyone in the central government? Can you speak against a minister in the cabinet? Can you say anything against any prominent person with political power? No, you can't. So free speech is an imaginary thing. For us in India, facing a despotic government, and I think like many people in the world who face despotic governments, free speech is the most difficult thing to attain. We've had a lot of cases, and I'm thinking about you students, and we have a case recently of a student in Delhi University who took a blank wall and painted on it something about an examination should be scrapped, where all the students believed that NET or something should be scrapped. And she was immediately suspended and threatened with expulsion for painting on a wall a slogan regarding scrapping of an examination. And we have protests all across India. In Ambedkar University, you must have read in the papers. In Ambedkar University, students are protesting and being threatened with termination, expulsion, suspension, all kinds of horrifying things. And I do hope such conditions don't land up in American universities, because I think now with certain developments taking place in certain parts of the world, professors and students who stand up for rights and say things that we have a right to speak. And you're being taught that actually even Americans in American universities governed by the famous freedom of speech coverage. Even you and your professors also perhaps may not have a right to speak. You can speak some things, but you can't speak other things. And the things that you love to speak about, unfortunately, you cannot speak. Kunal Kamran, you might have heard, stand-up comedian who said some things which were interesting to 90% young people. And they caught him and lectured him on Indian morality and Indian standards of decency. I'm sorry. Why didn't you fix it?
It's fine, sir. You're audible.
Yeah, but I'm getting a little upset by this interruption, if you like. Yeah. So Kunal Kamran, for example, who spoke up, got a lecture by the Supreme Court recently. So you know what situation we're working with. He got a lecture from the Supreme Court. And the other person, Alabadia, got a lecture on Indian morality and decency. And they were told, as one of the leading journalists in this country, that you will not be allowed to carry on with your programs unless you agree to abide by Indian morality and decency. Horrifying values, if you ask me. And that is the situation of India today. Now I'll come to hate speech. I want to make 2 points. Because as you can make out from my introductory talk, I don't like any restriction on speech. But when it comes to hate speech, I'll be saying something a little bit more complicated. And I'll tell you why I'm saying it, and I'll tell you why it may be perhaps correct. Today, there's an exponential rise in hate speech. Sharp increase in hate speech. Routine, every day. Everybody saying the most obnoxious things about Muslims, first. Second, Dalits. And so I'm taking a slightly nuanced approach towards hate speech. And now hate speech says, if you do that, if you attack people, words themselves are enough. Words. And there's that exponential line of increasing hate crimes. So exponential line of hateful speech paralleled by an exponential line of hate crimes, killings, mass murders, etc. And the two now are inseparable. The dividing line, if there was ever one in India, between hate speech by itself and hate crimes that followed is now illusory. No gap at all. And hate speech acts like a trigger without maybe the person intended, in most cases it's intended, but the gap between hate speech and hate crimes has evaporated. What should be done in circumstances where this has happened? And I believe, and I've been advocating this and I've been prosecuting people, that the moment you utter a hate speech against particularly Muslims and Dalits, which I know will escalate into a hate crime, even before it escalates, you must be prosecuted with the full force of the law. Because if you wait even for a day or 2 days or 3 days, the escalation will happen and the murder will take place. So hate speech must be prosecuted per se. Now there's a 2024 report, which you might like to read. It's the report of the Center for the Study of Organized Hate, 2024. And between 23 and 24, hate speech increased by a whopping 75%. So India is a country full of hatred. the land of Mahatma Gandhi and peace and kindness and spiritualism and all the things that we say the East has surplus of and the West has not enough. We Indians are very apt to use that sort of description of the difference between the West and East. India has become a very violent country, full of hate speech, full of hate crimes. And you're having this meeting at a very good time, actually. And possibly it's a trend all across the world. Be of some interest to you to see how America and American laws change, how the teaching of American law will change. And in the universities, to what extent some very prominent person can browbeat students into saying things and not saying things and so on. A notable shift took place in 2024, last year, which was that the role of central political leaders, central government, political leaders of the central government, leading the charge on hate speech as the instigators of communal violence, chief ministers of state, cabinet ministers in the central government, instigating the charge on hate speech for political purposes, whatever it might be. And they called for an economic boycott, one, of Muslims and Dalits. They called for arms, a call to arms. We, the majority community, must arm ourselves. And the description is so graphic, I don't want to repeat it here. To kill our enemy and to shoot and kill our enemy. The destruction of Muslim properties, including residential properties, and the demolition of Muslim religious places. You would have seen it, you would have heard of it, widely reported. Not one person was ever punished, charge sheeted, let alone punished, not even charge sheet. Then in 2022, we had a new development, which took even people like me by surprise. Started the hate speech campaign against Christians. And like I said, hate speech and hate crimes go hand in hand. So in 2022, there were 600 physical attacks on Christians in different states of India. They go to the prayer meetings, they go to the churches, they catch the pastor by his neck, they drag him out, they beat him up. The police will support them and take him to the police station. The police will be happy to put that pastor in jail. For what? For doing a Bible class or reading the Bible and so on and so forth. So 2022, 600, 23, 600, 24, 600. 600 cases every year. Hate speech against Christians and hate crimes against Christians. Now let me go to what happened in Delhi 5 years ago. The Delhi riots case. Riot is not really a good term to use because riot gives an impression it's two communities clashing with each other. I would call them the 2020 massacre case in Delhi. How does it start? It starts with a cabinet minister in the present government of this very powerful leader of ours. The present law minister of Delhi government, a member of parliament, and another member of the Rajya Sabha and so on. And we took a video of that and filed it in court, hoping that we'd get the prosecution for hate speech, coupled with hate crimes. What does he say? It's a famous slogan in India. It's now become a famous slogan. देश के गद्दारों को गोली मारो सालों को. To the anti-nationals of India, shoot the bastards. Can you imagine a cabinet minister, member of parliament, hate speech of that kind? And within 3 days, the Delhi riots began. So in my mind, I know there's a difference between hate speech and hate crimes and so on. To my mind, there's a merger of these two aspects of hate crimes. Hundreds of people were killed, properties were burnt, houses of the Muslims were looted. We went to the court with that video and said this is a hate crime straight away. Hate speech is a crime in our country. And see what followed, etc., etc. No court willing to touch it. Supreme Court treating it like a hot potato. Go to some other court. Go to the High Court. High Court also treating it like a hot potato. We go back Supreme Court, High Court. And in the end, 5 years have passed and the case has not begun. There's a lesson to be learned. Because we like judges, we like India's democracy, we love the constitution, we believe that the courts are doing justice. Justice is dead. And in the Supreme Court, there are some very fine judges in a minority now. Justice Oak is totally, I wasn't just being, I was not just saying nice things about him for the heck of it. He's truly an extraordinary person. I'm glad you called him here today. Truly an extraordinary person. Stood up again and again and again. But the institution is dying and the Supreme Court is dying and the High Courts are dying. And redressal for the poor, the only avenue, which was the judicial system, is now virtually dying. Before that came the Sikh riots case. I'm doing a little balancing act here between the present government of the present dispensation, political dispensation, and the previous government in Delhi. The Sikh riots case. As you know, or may know, one of the persons who killed Indira Gandhi was a Sikh, a security person, killed her. And there was immediate retribution against the Sikh community and hate speech against the Sikhs on a very large scale because government was in power, the Congress was in power. And there was a phrase which Rajiv Gandhi used. Sometimes hate speech comes in very charming terms. Very, very strange. But the people understand exactly what it means. And he said when he was asked about why he didn't stop. Rajiv Gandhi, sir, your Prime Minister, why didn't you stop these riots from taking place? These hate crimes from taking place? People are being massacred in the hundreds. And he said, his answer was this. Fatal mistakes people make in their lives. Rajiv Gandhi was actually a decent person. But there comes a time in your life where you make a fatal mistake from which you can never recover. All of you young people, take a lesson from that. Not to be too cocksure, overconfident, and so on. Always introspect. And consider even though you're doing very well, introspect as to what it is you are doing, saying. He said, when a mighty tree falls, the ground below it trembles. And those few words had such a magnifying effect that the entire party and its cadre took it as a signal that their prime minister was not stopping them. And the massacres took place. Potent words are, by themselves, just by themselves, potent, poisonous. So that was the Sikh riots of 84. Now, all these utterances on hate speech have a very good ally, Facebook and digital media. And we did a case against Facebook because what was allowed to be posted on Facebook against the Rohingyas in Bangladesh was resulting in genocide. And ultimately, the ICJ and so on came out with a report that the Rohingyas are the victims of genocide. Killed, raped, expelled from Bangladesh, thrown out of the country, forced to run to India, where we'll treat them also the same way. India will treat them in exactly the same way. So Facebook, what it does is, and you must understand this. I think many of you do. I'm just an old timer. You people are young, so you understand about all the digital media stuff and so on. Hate speech is good business. Hate speech is to be magnified and spread. And if you magnify and spread hate speech, your returns are enormous. Your ranking goes up. Your revenue is enhanced. And in India, Facebook has 350 million users. So who's this great partner in crime? Facebook. And others as well, similarly. So we did this case against Facebook, and I learned this during the process of that case, that they should be punished and not allowed to do this. They must change their algorithms. They cannot magnify hate speech. They must repel and remove hate speech, but they have no intention of doing it. Now, Facebook says in its defense in the High Court, we are only curators. We are a passive medium. Who knows who wants to put what on what? And we don't distinguish. We don't have any way of distinguishing, and we don't have any role to play. Somebody comes and puts something, all right. Somebody comes and puts the opposite, all right. An innocent bystander. So when it was pointed out to Facebook, and there was a US congressional hearing on Facebook. I wondered if any of you followed that. When it was pointed out, studies showed that Facebook responded to 2% cases and took down 2% cases of hate speech. And this is all hate speech resulting in murder. Like the Rohingya issue was resulting in murder, kidnapping of Rohingya women, killing of children and others. And of the 2% that they took down, half of them they restored when nobody was looking. And the hate speech in the Rohingya case contributed to the genocide. So hate speech is not speech. It's not simply speech. It's not only speech. Hate speech is as venomous as a poisonous snake. With due respects to the snakes, who in India we venerate quite a bit. But hate speech is very, very poisonous. Now I want to tell you something about the Supreme Court and hate speech. I have very critical views of the Supreme Court, let me tell you. And I started with great joy some 30 years ago. So full of hope, so full of life, so hopeful that we could do a kind of a revolution through the court system. And I now, on departure at some stage, I know that it's all a lie. At least today it's a lie. It may not have been a lie 10, 15 years ago, but today it's a lie. So one of the biggest instances of hate speech is this whole thing about Bangladeshis who came to India in large numbers, came to Assam. The war took place. The war of liberation in Bangladesh took place, I think, in 70 or so, 1970 or so. So there was a war between the Indian army and the Pakistani army in East Bengal. And many people were displaced, lives were shattered, properties were destroyed, and people ran away and came to India in large numbers. Many of them landed up in Assam. There's a famous case. It's called Sonowal. Do a search. Assam. Eviction of migrants, movement against migrants. The student union was full of hate speech. And they tried to push them back. Supreme Court comes into the way. Now look at the Supreme Court's language. how a Supreme Court of a country can fuel hate speech and virtually energize hate crimes. What did the Supreme Court say? India's borders are occupied by foreigners. Just look at the language of a constitutional court for which all of you, I think, have great veneration. A lot of respect. Students today must have much less respect. Be iconoclastic, be disrespectful, be questioning. But our Indians today, particularly even today, very respectful of injustice, of people doing injustice as well. Anyway, occupied by foreigners. And now who are you talking about? People who left their lands, came here, destitute, poor, destitute, illiterate people, without even any footwear on their feet. Our land is being occupied by foreigners. This has serious implications for internal security. The silent and invidious demographic invasion of Assam may result in the loss of vital districts. It's like an enemy invasion. They're turning into Muslim majority regions. It'll then be only a matter of time when a demand for merger with Bangladesh will be made. The rapid growth of Islamic fundamentalism may be a driving force. Bangladesh had long discarded secularism. I'll come back to this phrase, and chosen to be an Islamic state. Loss of Lower Assam will sever the entire landmass of the Northeast from the rest of India, and the rich natural resources will be lost to the nation. Anti-national. Now look at the language they used. And today in 2025, I'll tell you what the situation is. How a Supreme Court, guiding people in this venomous way, can cause massive loss of life. Hate speech through an innocuous Supreme Court judgment reported in a law journal where hardly anybody reads, English in the country, and see what effect it had on the country. And you remember that phrase, Bangladesh has long since discarded secularism. What the judges don't know or didn't know is that there were 5-judge bench decisions of the Supreme Court on secularism. One under army rule, but the second where they reviewed the army rule decision, again 5-judge bench. Bangladesh is a secular state where the majority religion is Islam. And the secular traditions in Bangladesh are quite pronounced. So a 5-judge bench, Bangladesh is a secular state. Now the result of hate speech in that case. It created a communal frenzy. 2 million migrants were declared non-Indian. 20 lakh, 2 million migrants were declared non-Indian by the government setting up what were called foreigners' tribunals to decide whether you're a foreigner or not, Indian or a foreigner. Poor people dragged to courts without lawyers, without money to pay even the bus fare to get to court. 20 lakh, 2 million people were declared foreigners. What were the consequences? Immediately, if you had not already been put in jail, you were put in jail. What is the punishment for entering India illegally without a proper visa and passport? 3 years. So they underwent 3 years in prison. Then when they came out, they didn't know where to go. Government didn't know what to do with them. So they were put in detention centers, worse than prisons, where many died in detention centers. And some of them stayed there for upwards of 10 years. See the hate speech which originated 20 years ago by 3 judges of the Supreme Court, 3 fallible human beings who were so full of themselves that they deliver this most obnoxious hate speech, which translated into so many deaths of people. And who were these people? They had small plots of agricultural land, half an hour, small plots of agricultural land, etc., etc. And when the National Human Rights Commission went there, they made a report which pointed out to the pathetic situation there. As a result of which, India wants to deport 22 million people, 2 million people. Bangladesh says no. So India has created the largest group of stateless people in the world. We created it by their judgment, by our law, by everything. So let me quickly finish because half an hour is over. So let me quickly go through 3 or 4 points that I want to do quickly. The Dalit lynching cases. The hate speech was, this group of people are selling and consuming cow meat. Lynched. Not long ago, 5 years ago. In the largest democracy in the world, hung from trees. Like what happened in the Mississippi, I think, many, many years ago. But the difference was in the Mississippi, they had the federal agents coming out and, investigating prominent people, catching them, arresting them. At least that's the history that I understand. But in India, nothing happened. The merciless beating of Jamia students because they wanted to take out a protest march to parliament. And the hate speech of the police. You are Kashmiris. Why don't you go to Pakistan? You're all Muslims. Hate speech followed by violence, the smashing of the CCTV cameras, and brutal beating of 100 students. Fractured skull, fractured arms, fractured legs, one student blinded in the eye. India is a wonderful country, really. Wonderful country for learning how to resist tyranny. I don't look at it negatively. I look at it as a chance for young people to resist tyranny and to learn on the ground how to resist. Then we had the Bombay riots again. And a judge of the Supreme Court, Justice Sri Krishna, made one of the best reports on hate crimes and hate speech ever. And he identified the policemen who had used hate speech against the Muslims while beating them, supporting the persons massacring the Muslims. One of the most lucid presentations of barbaric India, hate speech, hate crimes. And at the end, the government, which was a prominent right-wing government, said Justice Sri Krishna is anti-Hindu. But they said that to the wrong person because he was deeply versed in Sanskrit and he understood Indian culture very well. And he wrote a reply to this, I'm anti-Hindu. What is a Hindu? Which you all must read. Justice Sri Krishna's commission report on the Bombay riot. Who is a Hindu? Totally brilliant. And the last point I want to carry, because I've gone a little over is now I come to the Dalits. I spoke to you of lynching, that was lynching of Dalits. I come to you slightly complicated, and I'll take a position which might seem to be contradictory. I don't know. Maybe it is, maybe it's not. Words constitute the crime. Generally, I would say this is not correct. But the scheduled castes, the untouchables of India, have had such a long history of stripping of dignity, raping of women. It's not like any other group. There's a judgment of ours, Supreme Court, where they said if you call a person nigger in America, it's like calling a person chamar in India. I don't know. I don't think anyone would. I mean, I think nigger is a pretty obnoxious term. I don't know. Maybe times have changed, but I think it's a pretty obnoxious term for a person. And he said, just as you cannot use the word nigger in America, you cannot use the word chamar here in India. But there's an additional reason which Justice Kachu of the Supreme Court missed. Untouchability. A human being is not a slave, not just a slave. Like blacks were treated as slaves. The chamars are not just slaves. They were bodies, they were perceived as human beings whose bodies are inherently polluting. They lived with that. They live with it today. An educated Dalit getting a PhD from a university going back to his village will be told by his headman, sit on the floor. You're not supposed to sit on a chair. Their bodies are inherently polluting. It's the worst concept that you can imagine. So words, you call him a chamar, and you have committed a crime, provided you do it in a public place. You call him a chamar in his house, that's not a crime according to the Supreme Court. I believe that judgment may be right. But you call him in public, hey chamar, come here. It's a crime. Must be arrested for that. It must be put in jail just for words. Now that's provocative, isn't it? It's a little different from what you've been saying in the past. Words themselves don't constitute the crime. Words plus violence. But for Dalits, I believe there's a difference. And that's a difference rooted in our culture and history. There can be nothing more vulgar, nothing more obnoxious, nothing more hateful, nothing more destructive of the human spirit than this word, this phrase. You walk by the house, you're supposed to take a detour because you pollute the house. You dare to enter a restaurant, the restaurant is polluted. It has to be purified and you'll be punished. You take water from the well and that water is polluted. Anyway, think about it. And I like the phrase used by the Supreme Court in that case. The caste system is a curse on our nation. And the sooner as it is destroyed, the better. And one last point before I go. Hate speech linked with assassination. Assassination of journalists, right to information activists, writers. So you remember Gauri Lankesh, Kalburgi, Govind Pansare, Narendra Dabholkar, wonderful writers struck down by hate speech. They put faces up and put a red cross across it. The forerunner to the actual murder. One person said in Gauri Lankesh's case, that wonderful Gauri Lankesh, one bitch dies a dog's death. All the puppies cry in the same tube. And then when they killed journalists, they said, put up the faces of the journalists and they said, these are prostitutes. These are prostitutes and deserve to die. And they died. They were killed. Anyway, my dear friends, I'll stop on that. Thank you very much for listening patiently. I do hope you could hear me clearly.
Yes.
Loud and clear.
Because there's an eerie silence. So I'm not used.
Yeah. Thank you so much, sir. As always, your speech has been invigorating and nothing less. My colleague Devanshu wants to ask you a question.
Thank you so much, sir, for this very candid and passionate speech. All of us thoroughly enjoyed it. As you showed that the picture is very dire right now in India. but a lot of us do want to come back and help in making things better, making the free speech situation better, making participating in a way where like hate speech is prosecuted in a more egalitarian and better way. So, keeping that in mind, sir, what would you like to say to the young minds? So, with respect to, say, for example, the Supreme Court judgment in 2023 said that the police should suo moto register FIRs in a case of hate speech, and they should not wait for a complainant to come forward. Now, if somebody is a well-intentioned police officer or a well-intentioned magistrate, what can be done? What can be the standard which can be laid down to make things easier for them? Because right now, the words that are used to prosecute hate speech are um, feelings of enmity, hatred, or ill will. So,
I'm going to give you immediately a very unconventional answer.
yes, sir.
Don't look at the judgments. I told you that earlier. Don't look at the judgments. Don't be a lawyer. Be a human rights person. Be a young person with a troubled spirit, who you can feel your spirituality, because when you see injustice, you are troubled by that. Forget the law, forget all your books and all that for the time being. If you're a troubled person and you can see injustice and you say, I want to do something about this, you've got a starting point. And the starting point is deep inside you in your soul, not in the books and what judgments. And please, never be misled by Supreme Court judgments. It's a lie. It's nice lie. It's lovely to read, but it's never done. You mentioned the judgment on which said that, suo moto register. They won't register even if you make a complaint. Forget suo moto. Look inside you. You are going to a troubled area when you come back to India. And there are two responses possible. One is you say, oh, I don't want to do that. It's very hard. It's very difficult. I'll not get a good job. And the other is to welcome it and embrace it. Because if you're alive in your body, in your mind, and your heart and soul, this is the best training ground for a young person in human rights. To get into the turmoil, the uncertainty, the danger of trying to restore democracy in India is the best time to be alive in India. Unless you want a boring life. In which case, don't listen to me at all. You stay in America or wherever. America is not safe. So stay wherever you want to stay. But it's a huge challenge. It's a huge challenge. And it's a kind of a learning at a particular point in history and your history, which you will never get again. So embrace it now. Finish your studies, get your degree, get your basics so that you'll never be on the streets or hungry and so on. But don't go with the flow, because the flow in Indian universities, even the best of Indian universities and Indian colleges, the flow is deeply retrogressive, elitist. Build your own, like we built. We built a human rights law network. Once upon a time, we had 175 students, lawyers, doing cases all over the country. We got a little setback when our Prime Minister, beloved Prime Minister, froze our bank accounts. And he thought he would stifle us, but we weren't stifled at all. So please, that's my advice to you. If you're made of sturdy stuff and you can recognize your strength inside you, and sturdy doesn't mean you're the best speaker in class. Sturdy doesn't mean you're the best debater in class. Sturdy doesn't mean that you've won all your debates and you've got A's all across. No. Life will teach you that sturdiness is something deep inside you and it will emerge when it emerges. So have faith in yourself. Have deep faith in yourself and the company of your friends. And be ready to do something magical. Because young people getting together and doing things as their heart dictates, right and wrong, justice and injustice. And you build yourself like that and your colleagues in groups and teams, you will have a magical time in your life. You will win. Many years later, you will win. Because India is ripe for change. And the Indian young are not interested in all these things that the old tell you. I'm sorry for being ageist. They are not interested in the past. They're not interested in caste. They're not interested in religion and religious differences. They are interested in love. And that's a very fine way to end a talk, actually. They're interested in love. And if you can love yourself and your colleagues deeply, respect and love them deeply, and fight against all the barriers that come in your way, you'll be a very satisfied person at the end of your life.
Yeah.
I've talked too much today.
Thank you so much for this very encouraging advice, sir, and for giving us this guiding light. And I'm sure we have a lot of young lawyers here who are looking to create moments of magic as and when they go back and practice. I would like to hand over the mic to Professor Nadine, who has thoroughly enjoyed your speech, and she has made it very clear during the 30 minutes that you have spoken. So she wanted to make a comment.
Yes, thank you so much, Mr. Gonsalves. Colin, Nadine, so nice to meet you. I do feel as if we are colleagues in so many ways. First of all, if I am ever in trouble in India, or for that matter elsewhere, I want you as my lawyer. You are a fabulous advocate. And you didn't even need to tell the students about the special magic and joy that comes from fighting for what your sense of justice is, because you embody it in every single minute. You're talking about these terrible developments, but you are infused with joy and exhilaration about the opportunity to do something about it. And, that has always been such a passion of mine. I have been so fortunate to use my legal education to advance my sense of justice. And it's brought such enormous, you can't even say satisfaction, really joy. What I wish for all of my students, including the students I get to meet in talks like this, is that they will take advantage of their special legal education to advance whatever goals they believe in. It's important to earn our living for our families and ourselves, but beyond that, a legal degree can empower us to have the special joy in trying to make a positive impact on the world. Now, to the merits, as you well know, but the students here might not, just about every single point you made about India and the Indian Constitution and judges and, the violations of rights that exist on paper don't really exist in practice, that is all true of the United States. We had the Bill of Rights since 1791, including the First Amendment. It was a dead letter, basically, until the second half of the 20th century. And what changed was what brought about the change was the formation of organizations such as yours, the ACLU, the NAACP, American Jewish Committee, and so forth, because these rights are not self-enforcing. James Madison, the prime author of the Bill of Rights and the Constitution, himself said it's a mere parchment barrier between government abuse and actual people. The Supreme Court can't just reach out and, pronounce that something is unconstitutional. You need people to be able to complain about rights violations and to bring those violations to court. So that is an essential lesson that goes way beyond India. Just as the Constitution itself is not self-enforcing, you made the really important point that Supreme Court decisions are not self-enforcing. They are honored in the breach every day. So your language is very vivid when you say it's a lie. I would be a little bit more gentle and say it's a promise that has to be fought for to make sure that it is actually honored by every government official in every single part of the country every single day. And that's not going to happen by itself. That requires us lawyers to do it. Now, in terms of hate speech, I think we overlap quite a lot because contrary to a lot of binary rhetoric, I don't know anybody who says all hateful speech should be punished. And I don't know anybody who says all hateful speech should be protected. It's a question of where do we draw the line and what are the criteria and what are the rationales. And as the justice and you have both stressed, it is very context specific, very fact specific. So in the United States, you may never be punished solely because your message is hateful, but if in the particular facts and circumstances, the message is delivered in a way that causes immediate violence or threatens an immediate breach of the peace, then it can and should be punished. So, you know, one of the dramatic examples that you gave of saying, I took so many notes here that I can't find the, oh, right, shoot the bastards. That I think could, in the context, could well satisfy the standard that we've had since 1969, intentional incitement of imminent violence that is likely to happen imminently. Also, all of us free speech advocates in the United States recognize that in a country with different social conditions, these standards may well be satisfied more easily when you have a more volatile population that's more likely to explode in violence, that is less likely to be curbed by police officers and so forth. So it strikes me that the very same standards that we use in the United States might well lead to different outcomes in particular cases in India. And then the last point I'd like to make with the greatest respect is that I think there's a paradox, I won't say a contradiction, but a paradox in your point about relying on the law to punish hate speech as being something helpful, because you yourself show brilliantly that the law cannot necessarily be relied on. It is not going to be enforced against the most powerful and arguably the most influential inciters of hate when they are government officials, right? And they can spread hate with impunity, no matter what the laws say. And then you also ended so strongly by talking about how the culture in India is changing. And it's wonderful that you use the word love, which is the antithesis of hate. And that's why I think that we put too much, and here I'm echoing a big part of what you said, we put too much faith in law to bring about changes that are really in the human heart and the human mind. And that's where we have to concentrate in trying to dissuade people from being receptive to hateful ideas and hateful propaganda. It's a much harder road, but I think it's the only one that has any promise of bringing about any meaningful change. But my comment.
We would like to open the floor to the audience if anybody wants to ask a question to Colin, sir. Okay, please go ahead. Yeah, please go ahead.
Hello, Mr. Gonsalves. Can you hear me?
Yes.
My name is Ali, and I am a student of history and not law. I come from Pakistan, and I've had throughout my life many benefactors and teachers who've shared your surname. And I'm deeply grateful for your candor today. I learned a lot. I had a lot of fireworks going on in my head, so I took a bunch of notes. And there are two sort of provocations that I wanted you to respond to. The first one was that you spoke about hate speech, and it seems to me, as a student of history, that the hate speech, you've sort of seen it more as a symptom than a cause, because the way I sort of imagine it, hate speech is is, yes, a cause of physical violence, but it could also be a symptom of something that's already simmering in society. So I would like you to respond to that. And as a related point, I see this entire language of sedition, secularism, nationalism, and what's anti-national as sort of a procedural language of the nation state and of Indian nationalism. And it's a framework that each political dispensation just maps onto its opponents. You gave two examples, one from the 1980s, which was a very different political setup than it is now, but the procedural language is not very different. And I hate to imagine that it comes, this very idea of sedition, alongside this idea of anti-national, comes with a sense of self-righteousness. With terms like the secular, you gave the example of Bangladesh. Pakistan is no different, an oppressive society, perhaps, if not more than India, than an equally oppressive society. And it's remarkable how this prefix of anti is used alongside these terms. So anti-national is something that's defined against what it actually is. So if you could respond to these two, I would be really sort of grateful. Thank you.
Well, I think you made two comments, and both of them are accurate, and I agree with both. Sedition law, I explained already how it works and so on. What was your first question?
To see hate speech as a symptom versus a cause.
Correct. It is actually a sign, a symptom, if you like, a sign of something inherent in the body politic, where hatred and violence and vengeance and domination of society, certain parts of society, will carry on by identification of the weakest strands in those societies. You identify an enemy, you build up that enemy, you treat that enemy like a punching bag, and then you carry on with hate speech. It's a sign of something deeper. It is. It is a sign of society actually becoming very degenerate with no resistance to that tyranny. But resistance always comes. Resistance always comes. In subtle ways, in many ways, in circular ways, in protracted ways, resistance always comes. And when it comes and asserts itself, then the tyranny is crushed. But in that process, many years pass, many lives are lost, many things are gone forever. You're right, it's a sign of a very deep malaise in Indian society, a fundamental foul thing in Indian society. But it will go because people will resist. And tyrants always come crashing down, not on their own, because society mobilizes against them. That's what we're doing. As lawyers, law students, law teachers, we are mobilizing resistance against tyranny. We're not just lawyers sitting in our offices or going to courts and giving, arguing cases or standing in colleges and lecturing. We're on the streets, we visit areas, we mobilize people. We tell them what they already know, actually. We don't go to educate people. They already know what the nature of tyranny is. We just articulate it for them as a self-affirming act. That when you resist people trying to take your land, you're right. When you resist force with equal societal force, you're right. You're not breaking the law at all. So that's our role in society. To join the ranks of resistance. Till the end. Join it, live in it, be part of it, and not be afraid of it or think you're doing the world a favor. You're doing yourself a favor because you're happiest most when you're struggling against injustice, isn't that it? You're happy.
Hi, I just had a I just want to riff on what Professor Nadine was saying in terms of using the law as an instrument to address hate speech. If we divide it along two lines, one being speech that is backed by authority, which is the kind of speech that your presentation largely focused on, which gets, if not the express endorsement of a ruling dispensation, but certainly the condemnation of it. That on the one hand, which I think Professor Nadine was also stressing, what would be the efficacy of a hate speech law which needs to pass through that portal to be effectuated? One. Two, a large amount of hate speech that we see together.
I didn't get the question.
Okay, so my question is two.
Yeah.
So I'm trying to think under the broader theme of addressing hate speech through a legal mechanism, which is either the formulation of a new law which is against specific minorities.
Okay, just hold on. I'm not saying that we can address hate speech only through the legal system.
I don't mean it exclusively either.
Yeah, I'm saying something further. I don't think we will ever address hate speech, or for that matter, any major kind of injustice in society through the legal system. I came from the trade union movement.
Yep.
I spent many years of my life in the trade union movement mobilizing against, injustice done to laborers. I joined the housing rights movement where I spent many years campaigning and fighting against demolition of slums of poor people. The legal system is one tool, which was a very effective tool earlier, but has become a very ineffective and weak instrument of justice today.
So I actually wanted to highlight something slightly more perverse, let's say, that not only the legal system being an ineffective tool, but actually it becoming an instrument by which that oppression is perpetuated further. What I mean is now two scenarios. Scenario one, there
Hang on
is...
a second. Let me just address this because your questions are getting complicated. 1 second. I wouldn't go to that extent. I would agree, but I've heard of some professors in colleges in the UK and so on tell their students, don't practice the law because the law is capitalist. Ultimately, you'll just, cause people to believe in a system which is actually deeply regressive. I don't believe our legal system is at that stage. It is regressive in parts. It is progressive in parts. You saw today a judge who's been giving hundreds of extraordinary orders to people in distress. So I won't go to that extent because the implication of that, and I saw many young lawyers drift away, is that, there's no point really practicing because it's a capitalist system. Well, if there's a straw to be clutched at, you'll clutch at the straw.
I'm sure.
If you can give poor people some relief, you give them that relief.
No, we live by that every day, but my question is slightly more nuanced than that. I'm not asking for a normative evaluation of whether or not is there any point to the law at all. I mean specifically with hate speech laws, when you have two kinds of hate speech in particular, one that is backed and condoned by authority. So as in your instances as well, so for example, you were talking about where allegations of eating certain kinds of meat are concerned, you begin at one stage, and the person who becomes the victim of hate-based violence is also the person who receives an FIR on them for inciting hate speech. That is one sort of instance. But the other is when there are formulations, for example, when the judiciary tries to resist, or even legislators, when it has been known to happen at some point, when legislators decide to enact laws that ostensibly seek to protect minorities, that becomes the occasion for resentment, right? A certain kind of resentment-based remobilization that allows hate to percolate into those other forums of society, like culture, civil society, right? Where people are able to then marshal that resentment as creating new rationalized forms of hatred, right? So the hatred is not because this person is fundamentally evil, therefore I must hate them, but the law treats them differently is why I should hate them. And this is not new to anybody in India, right? Which you may call it
Like, for example?
You may call it Tushtikaran. There's the politics of mollycoddling, right? Where the fact that someone needs to be protected becomes the reason for which they need to be targeted now. The fact that they are.
Oh, you mean reservation?
Yeah, so reservation's a great example, but even the
Come to the point then. Come to the point.
not just reservation, but it's also in terms of like religious minorities, right?
Articulate it straightforward. You're talking about resentment or hatred against Dalits.
Not just Dalits, though.
Because the state, wait, let's take the point. That's the main point. No, that's a good point. Because they get protection by the state and they get accelerated promotions and they get, quotas in employment and education and so on. So hatred against them. All right. So what's the problem with reservation and
No,
that hate?
there is no problem with reservation. I'm saying state action is of two forms. One is where it backs neutral laws, which are then used against minorities on the one hand. The other.
Go back to your example. So if people hate us, hate
Yes.
Dalit, because they get reservation.
Yes.
So what follows?
What I'm saying
Hate
is
us. We hate them. We hate them because they are struggling to take away the rights of the depressed people. So we fight against them. So what's the problem?
No, the problem is this.
That's a kind of a caste struggle, no, taking place in society.
So my difficulty is that
on one side.
But my issue
on the
is
side of the Dalits.
Yeah, but my point is that then they end up losing their lives, right?
Who loses their lives?
The people who will struggle and lose out their lives.
That's all right. They're entering into a struggle to retain the rights that they have got for quotas.
Yeah.
And if in the process of their struggle they lose their lives, so be it. Lots of people in struggle lose their lives. Workers lose their lives. Tribals lose their lives. Lots of people lose their lives. But it's a just struggle. It's a just war. It's a just struggle, isn't it? So what's the problem if they lose their life? We can't say we'll struggle against oppression, provided we don't lose our lives. Our lawyers are in jail. Our lawyers have been executed in India,
But I do think that the cost is borne
die.
disproportionately by people who.
So you lose your life in a struggle for justice. I would love to lose my life in a struggle for justice. I'm totally ready for it.
So our proclivities for martyrdom aside, what I do think that we may have a
good one.
Disagreement on this.
No, not martyrdom. We're not enjoying losing our lives, but I'm saying it is so usual in society for workers to lose their lives. Working class people, every time a slum demolition takes place in India, a demolition a day, 2 to 3 people die. A child dies, the grandmother dies, somebody else dies. Everyone struggling to keep their house together is in fear of death. The bulldozer will come. They won't wait for you to get out. They'll knock the bricks down and you're inside and you're dead. It's the routine of life. It's martyrdom or anything. Or if you like, everyday martyrdom, if you like.
Yeah, but perhaps I was hoping for a little more, I think, rage against the quotidian there in your example.
Anyway, I got your point. I understood your point. But this thing about anger against a community because they have benefits from the state, well, so be it. We'll face it. We'll fight it. We'll resist it. We'll oppose it. That's why we choose sides in a war, right? The just against the unjust.
I think that's where my discomfort comes.
The poor against the rich. Simple phrases, but very truthful. In life, you'll have to choose, right? Which side are you on? Who do I put my talents, for the use of which group? You have to choose. People resent me for many things. Our enemies resent me for many things. They say, we don't like the way he talks. We don't like the way he argues. We don't like the point he's making. But I'm polite in my presentation, so I don't anger them to the extent that they'll put a knife in my heart. Although they must be thinking of that at some stage. You have to take sides and you have to take a very strong stand. And the fact that people hate you is of no consequence. We welcome it. It means we are effective.
Okay. Oh, thank you.
I'm so sorry. Due to paucity of time, just one last question, maybe, or maybe we can move on to Professor Nadine because we are slightly over the time. So We would just request Professor Nadine to take the center seat, and then we'll just take 2 minutes break to reshift the camera, and we'll start again. Colin sir, would you want to keep online, or it's
I
up to you?
wouldn't be
No.
if you decided to absent yourself so you can continue the fight for justice.
Okay, I can take the hint. I'm going.
But I
Bye.
look forward to meeting you in person sometime. Okay, let's make a promise to
Bye.
each other.
Bye.
Thank
Bye,
you so much,
Mugdha.
sir. Bye, sir. Thank you so much, sir.
Thank you for your
Bye-bye.
time, sir.
Yeah, yeah. Nice meeting.
Yeah, we'll take you. We'll just take a 5-minute break. Thank you. Excuse me, everybody. So this room is booked from 12 to 1, and we have overshot our time. So we are shifting the conversation to BW201, and we'll serve the lunch there. And just give us 1 minute to figure that out. 20 minutes won't be enough for Professor Nadine. Or maybe we can just, we can sit with the food in the next room. So just give us 2 minutes to figure out which room, and we'll just take the audience to that room.